We have in the studio Mainasara, Kogo, a legal practitioner and public affairs commentator, to discuss this issue. Good morning, and it's good to have you, gents.
Good morning, Nigerians. It's my honor being here. Thank you.
Great. Now, this issue about the fight against corruption, I mean, since the coming of this administration, we have seen it gain traction. The government has talked about how best to go about this. The president have expressed frustration, really, about the slow pace of the dispensation of justice in our courts. And now, we've heard also that former Chief Justice of the Federation instructed courts to designate certain courts for trying of specialized courts. But how far have we gone as far as that is concerned?
Well, first of all, we should appreciate the concern of His Excellency the President, going by the fact that among the three cardinal principles of his governance, the first one is the fight against corruption. The first one is the fight against corruption. That one is just a point of elucidation, because constitutionally speaking, Section 15 subsection 5 of the Constitution has made it mandatory. It says that every public officer shall in legal parlance is a mandatory provision, shall fight all forms of corrupt practices and abuse of power. It says there that you must fight corruption. So it's a matter of mandatory doing by His Excellency the President. All those he has appointed under sections 168, 174, 147, 150. In other words, ministers, heads of ministerial department and agencies, everybody is a mandatory provision, including the governors, their commissioners, members of the diplomatic missions, members of the armed forces, members of the academia, everybody, once you are part of the state, because it says the state shall, the state must. You must fight corruption in all its ramifications. Now, coming to the issue of the legal system, if you don't get your legal system correct, no society can prosper better than the quality of its legal service delivery. And it is because of injustice, because of deficiency in justice delivery, that you see all the problems bedeviling the nation currently. Section 36, subsection 5 of the Constitution, that is where the albatross is. That is where the problem is. Because Section 36 of Section 5 says, no matter how grievous your perceived offense is, no matter even if the totality of the circumference of Nigeria constitute the magnitude of your offense, you are still clean without any dent until adjudged wrong by a competent court of law. That particular section really worries me. I sleep, I wake up under that distance, because it gives a window of leverage for somebody to go and amass public treasury and get money, and then he has the leverage to get the most sophisticated lawyers he can get. Pay them money, they will go and defend you, they will use technicalities. And at the end of it, there is that particular provision equally in our legal system that says you must prove beyond reasonable doubt. There is no yardstick to calibrate the measurability of the doubt. So anything that the judge can use his whims and caprices and say, I have a little doubt on this. By that, he has the fiat to really say that you don't have sufficiency of facts to nail that particular distance. And then when you look at it paradoxically, you will say that the legal system has come with a lot of ambience under which you can be able to fight corruption. For example, Sections 230 down to Section 304 of the Constitution has given a very comfortable latitude for all the judiciary, from the lowest to the highest level, to administer justice. To administer justice in the interest of the state, in the interest of the citizenry, in the interest of the credibility, in the interest of the sovereignty, in the interest of the governmental hegemony in Nigeria. But unfortunately, what we are seeing really is not giving us the expected service delivery. Hence, if we want to really fight corruption, based on what we are seeing now in the current dispensation, sincerely speaking, I'm in total and absolute support that we need specialized courts. We need specialized courts, not just the courts only. You need, first of all, to establish some courts. There are problems disturbing us. The problem of anti-corruption, you need to have anti-corruption special court. or whatever name you want to give it. You need to have cyber crimes and terrorism court. You need to have that one because of the series of problems we are having with terrorism and the rest. The courts are finding it difficult to even prosecute and convict them. Some people are even saying, give them amnesty, give them forgiveness without due recourse to the magnitude of the criminality they have committed. And then there is this issue of child trafficking, child molestation and the rest, which unfortunately most disappointing and most regrettable. Greater number of the states have not even domesticated the Child Rights Act, which means they are not even in support of that very fantastic legislation that will really bankroll us to the correct streamline of the world happiness. So you need specialized court like that. But in establishing specialized courts, we have to really be sincere. You cannot, it is not so much the establishment of the courtrooms, the structural buildings that is important. You understand. But it is not so much also the verbose, technical, professional competence of somebody coming to speak English or to write excellent, rosy judgments. That is not the issue. The issue is the faculty of fear of God still in the brain of those to head the judicature. Faculty of the fear of God. You should believe that as a judge, you are the vicegerent of God there in that umpire to transcend justice to the cheated. To the cheated, whether the cheated is the state, whether the cheated is an individual, whether the cheated is an institution, it is your responsibility to serve as a representative of God. Therefore, the government has to calibrate what is the quantum of your fear of God first. What is the quantum of your patriotism, nationalism, and disposition?
Well, that's also another contentious issue to determine.
Because if you don't have credible judges at the helm of affairs, it will be garbage in, garbage out, and those, like the Holy Bible said, vanity upon vanity.
Yes, I agree. But there are also those who say that, look, you cannot create special courts by mere pronouncements.
Of course, you have to amend the Constitution.
What will it take in our, situation to create special courts for?
Well, it is simple. You amend sections 230 to 304. By the time you do that one, it will automatically take care, because when you amend that one, you now create a judicial arm of the government. Not judicial, a judicial structure of the government by name of so court. You create it, either you make it at par with of concurrent jurisdiction, at par with what do you call it, federal high court, or state high court, or court of, or whatever. You think of creating that particular court and then give it the level of authority you want it to leverage upon. And then when you do that one, you have to, equally, it is very, very important, you amend section 36 of section 5 of the Constitution. The amendment I want there is the amendment that by the time you say that everybody is adjudged to be innocent, you understand. In other words, you are taking the prosecutorial type of adjudication, which is different from the inquisitorial type. In other words, you are taking the Western world type of legal system. That is the decision. It is better we now begin to test the Eastern world type of legal system. In the Eastern countries, especially the developing countries of the Eastern world, you are first of all to be, for example, Mr. Ayuba, they will say, Mr. Ayuba, you are charge of this. Tell us, convince us as to the reasons why this judgment should not be inflicted upon you. You understand? Which is the opposite of which is what we are pressing. So,
in other words, you are considered guilty until you prove
exactly innocence. Innocence. The onus will never be shifted on you. You understand? Because when, but in the practical sense, what we are doing in the country is that somebody who has not seen you while committing the offense, somebody who is not there, will be asked to go and investigate.
But isn't it a standard principle of law that you are presumed innocent until proven?
That is what I am saying as per section 36 of section 5 of the Constitution. That is as per our legal balance. You understand? Law is supposed to be made for man, not man to make himself for law. You understand? So what I am saying is that aspect you are pronouncing, that is the aspect I want it to be changed. So that
Can it be changed? If you change that, will it not be...
No, countries that are practicing it are there. Many countries are practicing it, and they are having more civilized stability when you come about legal system. They are stable because the essence of the law is to sanitize the society. The society is being sanitized. People are being penalized rather than the type we are having here on account of any simple, slimy technicality. They will say that we don't have sufficient grounds to convict him because it has not been established beyond reasonable doubt. So the reasonability of the doubt, which the same law did not come with the yardstick to measure, up to which percentage is it reasonable, up to what is it unreasonable. You understand? It is therefore subjective because it has to do with the mindset of the judge. And remember, he is a human being. He can be influenced by whatever emotions, by whatever sentiments, by whatever inducements in court and outside the umpire he is sitting. So many things can happen. So by the time somebody is committing criminality, put the onus on him. This is what the law says. That if you are caught doing this, you are adjudged to be a criminal until you prove that you are not. So let him be the one to prove. Rather than this in place of the committal of the offense is one. Number two, the witnesses that are seeing you are different. Number three, the officer that is supposed to have the responsibility of investigating you, the IPO, is different. By the time the IPO, the police officer, finishes investigation, he now pushes it to the ministry. By the time it reaches the ministry, all these are officers sitting in their comfortable air-conditioned room. They are the ones to analyze and bring charges. The charges of which did not happen to their eyes seen. They were not there when something happened. So they now prepare the charges based on the state of their mind, like I said. Then at the end of it, those people that prepare the charges may not necessarily be the ones to even go and prosecute in the court. Okay. And then, so by the time you see all these kind of things and efforts, cries and appeals have been made, several fora we have made appeals that whenever you want to go into criminal prosecution, let it be a totality, a wholesome something. From the person to investigate the first happening, down to the person writing, framing the charges, down to the person prosecuting, down to the decision. The totality of this team should be there so that there will be a joint kind of a symbiotic kind of exercise to be able to establish the decision. But in Nigeria, you will see the moment, I must give credence to the judiciary, not the judiciary, the media. I must give credence. I have highest respect in the media. They are discharging their credible, onerous responsibility as the fourth estate of the realm, in tandem with Section 22 of the Constitution of the Federal Republic of Nigeria, by being the first ones to be reporting most of these things. By the time they now report it, it becomes a matter of the media. You will see that officers in the prosecution wing will be busy trying to, the first of all they will do is to arrest the person. Arrest the person. Human rights group will start talking about you don't have the basis to detain him beyond 24 hours, blah, 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 blah. After some days, they take him to the court. You will discover that by the time they are taking him to the court, they have not even finished the even preliminary investigations to be able to really match the technical investigation with the items of the charges. The items of the charges they want to bring. So that is the reason why you will discover that as the case is going on in the court, surprisingly they will say, we are amending our charges. Okay. We are amending our charges. They will be knocked off on this, say you don't have sufficient distance to nail him on this, then they will say, okay, we are bringing 17 more charges, okay. 70 charges and the rest.
Now, presently, a lot of people have lost hope in Nigeria's justice system. And this is because of the delays we have, in trial of these cases. Do you think a computerized legal system could work in Nigeria?
I don't think so, because the magnitude of corruption in the system is really highly unbearable. You need a computerized judicial system where they have three instruments. The first one is that they have the feel of the nation like their own God. They are really interested in serving the nation, not serving the pockets. You understand? By the time we now decide to imbibe this contractocratic, capitalist kind of system, which is aimed off at self-enrichment. You are denouncing the patriotism you are supposed to have as a citizen. In other words, you see countries whereby when there is national anthem, somebody hold his head like this, you will see tears rolling down the cheek because of the feel of the country. He believes in the country. You understand? He believes in the country. But here we are in the country now, that one is not there. Number two, you have to have people that are really taking this responsibility as trust. The judges, the registrars, the lawyers, everybody that is a component stakeholder in the judiciary should take the responsibility of it as a trust that is representative of God to dispense justice. Is the representative of God to ensure justice there, even if it's justice against your own self, justice against yourself, justice against the system, justice against. Make sure that you are trying to promote manifest, transparent, and sincere justice down to the DC. By the time you now say, okay, let us go into electronic this, number one, do we even have the literature level to even go into that? Number two, do we have the technical, professional, scientific competence to go into that? Number three, how sure are you there will not be proof of some misdeeds as far as these cyber kind of offenses that we are talking about are concerned regarding that? And then number four, by the time you go into e-judiciary, everybody will be able to understand, to even forecast what will be the judgment ahead of time.
But some have said that part of the reasons why we have these delays is because you have judges reading a longhand, and that it stretches the whole process.
No, that is not the reason.
The whole process.
That is not the reason, except if you have a lazy judge. You understand? It's not the reason. The main reason, I agree, the workload is too much on them. But establishment of so many more courts will go a long way in solving that problem. For example, let me give you an example.
Wouldn't it be more burdensome
let me give you
more courts?
No,
especially as we talk about the
essence of the resources, the essence of the money we're having is to service delivery to the people. Money is not meant to serve politicians alone. It's not meant to serve politicians. It's to serve the people. And one of the ingredients of serving the people is serving the judiciary. Let me give you an example. If your case from Court of Appeal is going to Supreme Court, there is no magic you can play, except if it is a government-related case, or is something that is taking the attention of the country. The media have overbloated it. But otherwise, it is difficult for you to get your case listed within 20 years. Because in the Supreme Court, we have how many courtrooms? All the cases in the thousands of the high courts we are having are ending up at the Supreme Court. And there you don't have, how many courtrooms you have? The biggest courtroom there is a ceremonial courtroom. Then two other courtrooms. How many judges do we have? You should decentralize the Supreme Court, for example. You should have Supreme Court in 6 judicial divisions, or 7 or 8 or 10 judicial divisions, Supreme Courts of Nigeria. So that any judgment is given is a judgment of the Supreme Court. Or you can have specialization under the Supreme Court. For example, Supreme Court of the Constitution, Supreme Court of Criminal Law, Supreme Court of Land Law, Supreme Court of Commercial Law, Supreme Court of International Arbitration, Supreme Court of Marriage and Guardianship, Supreme Court of Cyber Crimes, Supreme Court of Terrorism. You should have specialized so that at the end...
Is this where the corruption court...
No, I'm giving example. So that from the Court of Appeal, you understand, it should go there and there are designated judges. Not this way that a matter will reach the Chief Justice of the Federation, then he will now assign it to a number of judges. 5 judges or 7 judges, depending on whether it's a constitutional or a regular matter. Then he say you should go and handle it. You understand? Justice delayed is justice denied. There is no reason why you should be having. And then going by the other this, because of the number of workload on the judges, you'll discover that it is practically difficult on the average for you to have a case a simple case for you to have it administered within 5 years. It is practically impossible. It is practically impossible. So you should have more number of courts. You understand? There should be a high court at every local government.
So what is stopping this from happening? Is it lack of funds?
No, they don't have
the will to do that.
They don't have the right to appropriate money for themselves. Probably there is laxity on the side of the judiciary. Probably there is laxity they do not propose. You know, in budget making, it is what you propose that you will be given.
But the judiciary is one of the arms that gets its own funds directly from the federal government.
I'm talking about the budget. What did they plan? Is there any sound planning for that? What did they plan for that? You understand?
Who is supposed to plan that for them?
The Chief Justice of the Federation is the Chief Executive Officer of the Judiciary in Nigeria. The Chief Justice of the State is the Chief Executive Officer of the Judiciary in the state. And there are chief executive officers at the various categories. The High Court, the Federal High Court is there. The Court of Appeal is there, the President of the Court of Appeal. These are the people that should bring about practice and directions, operational practice and directions for the courts. And these are the people that should bring about the demands of the judicature, the demands of the judiciary. These are the demands that we want. If it is electronic something, they are the ones to bring it. If it is increase in the number of courts, they are the ones to bring it. It is increase in the number of judges.
So are we saying they are using archaic, form of, administration?
Well, with due respect to the legal profession which I belong to, you must appreciate that law is a conservative profession. It's not a progressive profession. You understand? It's a conservative profession. And you'll discover that once a judge is comfortable, he will not be thinking of how to develop the decision for it to be more fantastic, better than during his own time. You understand? So it is important, but where they have not done it, there is no reason why the Attorney General should not bring it up. Under Section 150 of the Constitution. He is the Chief Law Officer of the Federation. He can initiate all these things. If by any accident I am the Attorney General of the Federation, in all honesty and modesty, I will institutionalize all these things I'm saying. I will try as much as possible to bring about bills at the National Assembly, executive bills that should establish specialized courts, that should decentralize courts, that should expand more number of courtrooms, that should have more number of judges. You understand? There is nothing more important to be done in any country than justice delivery.
Do you think that the confirmation of judges has been politicized? That's why we are not saying that.
I don't want to go into that because whereas not only politicized but compromised, by right we know of that one. Professionally speaking, as a senior lawyer, I'm not professionally, what do you call it, to say something like that. I don't want to say it. But definitely, judicial system needs to reform. Legal system generally. Our legal system generally. If I am to advocate for reforms of the legal system, sincerely speaking, the first thing I will do is that you will have the leverage to go there, even though it is there stated theoretically in the Constitution. You can go there and defend yourself with or without any lawyer. You understand? This idea of wearing these medieval clothes, black wig and gown, and black gown and wig, and I will remove all those things. There is nothing wrong in you to appear like this and argue the case. What is important is the substance in your brain that is coming through your mouth, not your dressing.
Will that not strip the legal system of its, culture and tradition?
It is
you said that it's a conservative.
Yes, that baboons culture and tradition, you understand, is intimidating, especially an illiterate man when he gets to the court. You understand? It's intimidating him. He sees something which is unnatural, for example. By the time he gets there, you have already made the scenery intimidating to him, by virtue of which you have weakened his zeal to get justice. You have already finished him. So look at even all the advanced countries. How many of them are using this type of colonial this. I will advocate for those things to be removed. Many things, I am telling you, Ayuba, many things I will advocate for them to be removed, so that justice to the doorsteps of common man. That is the slogan I will bring. Justice to the doorstep of common man. I will make sure that in every local government area there is a court there. Apart from the court there, I will make sure that even this specialized courts we are talking about, there should be timeline. There should be timeline. No case should be there beyond, for example, 6 weeks. 3-4 weeks there should be courts of summary trial. You are accused of this. Tell us, convince us as to the reason why you will not be convicted. Like I said, that is the way we will put it. Not to say somebody should come and argue something that was not there in his presence, to argue that yes, you committed that offense.
So would you say that?
And then it says if there is any iota of doubt, reasonability of doubt in the mind of the DC, he should throw it out that there is no sufficiency.
Okay, I think we're going to get right back to that discussion after this short break. We are discussing specialized court for corruption cases with Mainasara Kogo, a lawyer and public affairs commentator.
And if you're just joining, you are watching Daybreak on Trust Television. Here we are discussing the conversation about the creation of special courts to try corruption cases. And we have in the studio Mainasara Kogo, who is a legal practitioner and also a public affairs commentator in the studio. Now let's end this discussion this morning by getting your final thoughts.
My final
on this.
My final thought is that, sincerely speaking, with all sense of seriousness and patriotism, President Buhari should take this as the legacy he wants to build. Please, even if it's only the establishment of these specialized courts, court for anti-corruption, court for cyber crimes and terrorism, courts for rights of the children and the women, courts, this type of specialized courts, even if he wants to create a legacy of that, please, it will be the greatest social revolution for this country. Because this is something that will save the foundational fabric of justice in the distance. The essence of all governance, the essence of everything you are saying, democracy as a whole based on section 14, subsection 1, you understand, is talking about sovereignty belongs to the people. Now, if sovereignty belongs to the people, if we are doing the judicial system whereby the money back takes it all, we are not being fair to the majority of the citizenry. Out of 210 million Nigerians, over 200 are poor people. We should therefore consider the majority. That is the essence of democracy. Otherwise, if we don't do that, we leave it that way, then automatically it is contrary to section 36 subsection 5 of the Constitution. It is contrary to section 14 subsections 1 and 3. It is contrary to section 15, section 16, section 17, sections 21, 23, and 24 of the Constitution. These are the provisions in the Constitution that talks about natural justice, equity, and fairness in the interest of common man, in the interest of everyone. So let it be justice for the common man. That is my final conclusion.
All right. Well, thank you so much for coming on the show and sharing your thoughts on us with us in this program. We really appreciate that. Hopefully, we'll have you join us again another time.
Thank you very much.
And that was Mainasara Kogo, a legal practitioner and also a public affairs commentator, sharing his thoughts with us on the issues of about fight against corruption in Nigeria.